So yeah, before we begin, there's a couple of housekeeping items. So you'll receive the recording and slides in your email. You can submit your questions in the chat box and we will answer them at the end. And if you can please complete the survey at the end of the webinar. You can also claim your complimentary consultation. So all attendees are eligible to receive a free consultation with us to discuss how we can help you with your contracts or any of your legal needs. To request your free consultation, provide us with your contact details in the survey that appears at the end of the webinar. Okay, so our agenda for today is we are going to be talking about commercial contracts overview. Then we're going to be looking at breach of contract, dispute, negotiations and communication. Then we're going to have a look at ADR, being arbitration and mediation. Then dispute settlement strategies, and we'll have time for a Q&A hopefully towards the end. And now Jessica is going to start with a commercial contracts overview.
Thank you, Gemma. So the first thing we wanted to discuss today was what is a business contract? A business contract creates and governs the contractual obligations you and other parties will have to one another. Now, it's important that a business contract clearly details the commercial relationship and contains terms that ensure that it will function effectively. We've set out a few key terms on our next slide that we recommend to our clients when drafting a business contract, and I will go through these briefly now. Firstly, we recommend identifying the contractual parties. Any business contract should contain a term that clearly describes the individuals or the business that are parties to the contract. Contracting parties have certain rights and obligations that other individuals will not have, so it is important that these have been defined. It is common practice for this to be the first clause of the commercial contract. Secondly, we recommend including a contractual term. The term of the contract would include both the commencement and the termination date. Such a clause would ensure that the parties are aware of the period that they have to uphold their contractual obligations. Next, we recommend setting out each party's contractual obligations. We recommend that the business clearly states the responsibilities that each party is taking on. For example, a contract for the sale and purchase of coffee for a cafe would include a description of the goods the supplier is to provide, for example, the type of coffee beans and the quantity of bags for each coffee delivery, how the supplier will deliver these goods, such as by courier once a week on a Monday morning, and an outline of the payment of these goods. This outline would include the price of each shipment of coffee beans, how often you'll make this payment to the supplier, and the payment method. Fourthly, we would set out the rights of the parties. Now, although contracting parties are taking on obligations under a business contract, they are also entitled to receive certain rights and benefits. For example, if you enter into a contract to supply goods, you have a contractual right to payment in the manner specified in the contract. Likewise, as the purchaser of the goods, you are contractually entitled to be delivered these goods at the requisite time and the specified quantities. The next term we recommend is any contract variation or amendment. Now, it's not uncommon for parties to change their obligations once they have already signed a contract. So we recommend setting out a process in the contract for how contractual terms and obligations should be changed or varied. Some business contracts, for example, contain a no oral variation clause. This provision would specify that any contract changes cannot occur orally and would have to be in writing. The sixth term we have mentioned is any assignment of contractual obligations. Now, an assignment is when a party to a contract transfers or assigns their contractual responsibilities to a new person or company. This new person then replaces the assignor as a party to the contract. Now, a business contract should specify whether the parties are entitled to assign their contractual obligations. And if assignment is available, a process should be detailed as to how this should occur. For example, an individual may only assign their responsibilities if they have received the other contracting party's consent. Now, another term that we would always recommend to our clients is a dispute resolution clause. Throughout a contract term, it unfortunately is not uncommon issues to occur between the parties, and that is therefore best practice to outline how a dispute would be resolved if it should arise, how to maintain the business relations if it does arise, and how to avoid court proceedings. We recommend the dispute resolution clause would include the definition of a dispute, how the dispute resolution process is to be triggered. For example, one party may have to provide notice that specifies the nature of the dispute to the other contracting party, the rights and obligations of the parties in the event of a dispute, the process of dispute resolution that will be employed, such as mediation or arbitration, and an acknowledgement that the resolution should be fair and catered to reflect each party's interests and circumstances. And last but not least, a termination clause. There may be instances where one of the contracting parties wishes to or is entitled to cancel the business contract. So it's important that a termination clause includes A, the grounds for termination, such as a breach of essential term, B, the protocol a party should follow. This protocol may include providing the other party with notice, and C, what is to happen in the event of a cancellation of a contract. For example, a party may have to return some materials to another party. My next slide just outlines what is an express contract term. Now, it's important to note that the parties can express terms orally, as specific terms may be implied by the contracting party's conduct. We always recommend documenting the terms of the business agreement in a written contract and having it signed by both parties. A written contract also provides that all parties can read over the agreement to ensure that it does not contain any unfair contract terms. And it's not uncommon for a business contract to be written or verbal and develop and change over time. I then briefly have described what an implied contract term is. It's basically the opposite of an express term. And implied terms may be terms both parties believe to be part of the contract or terms created by statute that are not written down. And implied contract terms can cause issues if one party does not believe that that term has been implied. More on that later. I will now pass you on to Gemma to discuss breach of contract.
Thanks, Jess. Okay, so when we're talking about business disputes, one of the most common business disputes we deal with typically stems from a breach of contract. A breach of contract usually occurs when one party fails to do what they agreed to do or declares that they are unable to uphold their obligations under a contract. For example, under a supply contract, one party fails to deliver the goods within the time specified in the contract, or otherwise has advised in advance that they're just not able to supply the goods at all. So when we're looking at breach of contract, before taking any action, we always recommend that you try and understand the breach as much as you can. So determine what kind of contract breach has occurred, as this may impact how you can resolve it. So breach doesn't always mean that you can terminate the contract. You'll need to consider the nature of the term that was breached, again, whether it's oral or it's expressly written in your contract, and the seriousness of the breach. Hopefully, you have a written contract or some written terms that expressly sets out the terms agreed, and you can carefully review these to confirm the breach. It's not uncommon for contracts to dictate or limit what parties' rights are upon a breach. So again, you really need to be aware of the terms that are in there. So, for example, the contract may set out specific conduct which will amount to the breach, which will be relevant to your specific facts and circumstances of your contract. Any notice requirements relating to breaches, so time to rectify. So again, timeframes for remedying any breach, any rights to terminate for breach, an agreed amount of damages for breach, or an agreed dispute resolution process. Otherwise, you may be able to rely on implied terms in the contract to confirm the breach. Generally, a breach of contract may be considered either a material breach or a minor breach. Material breach occurs when a party receives something substantially different to what the contract specified. This is generally due to one party's failure to perform an essential aspect of the contract, And as such, the parties can no longer fulfill the purpose of the contract. So using the example of a supply contract, a failure to supply the goods at all would be a material breach. A minor breach, on the other hand, occurs when a party breaches a non-essential obligation under the contract. In these circumstances, the parties may continue with the rest of the agreement without altering the purpose of the contract, unless sometimes there might be multiple minor breaches, and these can sometimes add up to a material breach. It can often be unclear whether a term is essential or whether a breach is sufficiently serious to allow for termination. And these questions can get even more difficult if the underlying factual scenario is disputed between the parties. This is why terminating a contract for breach can be quite a complex question to deal with. Not all breaches give you the right to terminate, and there are many factors that will need to be considered. If you're considering terminating for breach, it's important that you seek legal advice before doing so. If you terminate a contract without a proper basis or without following the prescribed termination processes set out in your contract, this can open you up sometimes to a claim for damages. Okay, I'm now going to pass you back over to Jess to talk to you about negotiations and communication when disputes arise.
Thank you, Gemma. I will now quickly run over communicating with another party when a business dispute arises, as it is important that you are aware that everything you say or write in the early stages of a commercial dispute, unless it is marked without prejudice, can end up as evidence. Therefore, we recommend in the first instance, you should pick up the phone, have a conversation with the relevant party, as disputes can often be just a misunderstanding that can be quickly resolved. And a phone conversation might be all it takes for the parties to have a meeting of the minds, especially if it hasn't been raised before. The next step would be more formal written correspondence, setting out your position in the dispute, whether you're responding to a claim by the other party, and whether you are thinking about initiating a claim against them by way of legal action. If court proceedings are contemplated, we would always recommend engaging a lawyer in the earlier stage of dispute to avoid any unnecessary complications. Now, communication tips. We've listed a few tips on this slide, which should be fairly self-explanatory when it comes to communicating with the other side, but we do recommend avoiding emotional or inflammatory language or any personal attacks, setting out the factual matters clearly, attaching any relevant evidence. These could be bank statements or invoices, checking the correct person you should be dealing with, and confirm they have the authority to act on behalf of their business. Providing a deadline for a required response, such as 7 days or by 5 p.m. If you do communicate directly with the other party, make notes of everything said during the conversation, or get consent for it to be recorded if you are worried about it. Be open and provide information where appropriate to ensure that information is communicated properly, and always keep copies of written correspondence relating to the dispute. Now, most of the audience today would have heard the term without prejudice, especially if you've been involved in a business dispute before. It is important to note that communications or discussions which are marked without prejudice are for the purposes of settlement only and typically cannot be used later in legal proceedings if the matter ends up in court. So basically, it allows parties to speak freely and explore a wide range of settlement options. Without prejudice discussions enable you to propose creative solutions or make offers of compromise without the fear that the court will become aware of any of the concessions you have made or that your words will be used against you. My next slide is just a few questions and answers about communication in regards to without prejudice, which I commonly come across when I'm speaking to clients. So finally, my next topic is alternative dispute resolution. Alternative dispute resolution is any method of resolving a dispute or a conflict that does not involve going to court or litigation. The method that you choose will depend on your desire to spend on legal costs, the amount of time you wish to spend settling a dispute, the confidential nature of the dispute, as court proceedings can be made public, the nature of the relationship you have with the other party or with parties involved, and your desired outcome. The most common alternative dispute processes are negotiation, mediation, and arbitration. The key matters that distinguish the ADR, as they're commonly known, are whether you and the other parties want control over the process and the outcome, whether you wish for a neutral third party to assist you in achieving that outcome, and whether you wish for a neutral third party to impose a decision. It is important that you always refer to the business contract, if there is one, as some contracts will require the parties to attend either mediation or arbitration before they actually commence proceedings through the courts. There also may be terms that set out positive obligations on parties regarding disputes. So the next slide is regarding mediation. Mediation is a dispute resolution process where a neutral third party, or mediator, facilitates the negotiation between conflicting parties. In short, the mediator's role is to assist the parties with resolving their dispute. A good way of thinking about it is that you can consider mediation as the middle ground between negotiation and arbitration. The mediator will assist in making your own decision and an agreement instead of having a decision imposed or being left unfacilitated. The mediator will help you and the other party to define legal issues, draw out relevant information, explore potential settlement options, and negotiate a beneficial settlement agreement. If the parties are able to resolve their dispute, the mediator will draft a written agreement that will outline the agreed resolutions between the parties. In summary, the key elements of the mediation process are that the mediator will facilitate the outcome, it's informal, consensual, and confidential, and the parties can negotiate flexible solutions that do not conform with any specific legal or general guidelines. Employment-related disputes typically utilise the mediation process. So the benefits of mediation are that it is quick, business-friendly, cost-effective, and it can be organised between the parties with or without the assistance of lawyers. The main benefit being a quick result that avoids the need to go to court. Now, the other form of ADR is arbitration. Arbitration refers to a dispute resolution process in which conflicting parties agree for a third party, or an arbitrator, to come to a final resolution of the dispute. It is a contractual method of dispute resolution whereby the arbitrator has the authority to make a binding and enforceable decision due to an agreement that's been made between the parties. The key elements of the arbitration process are that the arbitrator will decide the outcome. There are some similarities to the court process in that it involves witnesses, can call evidence, and presenting legal arguments. There is also a large amount of flexibility as to the procedural requirements. And unlike mediation, it is conducted by one or more appointed arbitrators. Generally, it's similar to the court in that the parties are required to file documents in advance. An arbitrator conducts the formal hearing. The arbitrator will hear the evidence and make a finding, and the decision is usually final and binding and enforceable by the courts. So the benefits of arbitration are that it's more structured and formal, but more efficient than going to court. And some benefits can include confidentiality, privacy, timeliness, unlike court, flexibility, and the costs are cheaper than going to court, and obviously having a final decision which is enforceable by the courts. So I'll now turn to Gemma to go over some strategies to settle your business disputes.
Thanks, Jess. Okay, so we're going to have a little bit of a look more about the strategies to settle the disputes. So we should always know that what your legal position is from the outset. So make sure you have an accurate understanding of your contract and the facts and circumstances. So it's crucial that you know the basis of any claim against the other party, including the key issues in dispute, the terms of the contract that you wish to rely on, the specific facts and circumstances relating to your dispute. You should have an understanding of your rights and obligations under any relevant contract terms, should be aware of what the relevant law says, and also always take into consideration the risks of litigation. And in terms of that, you should always be aware of the bottom line before commencing a dispute. So what you may lose in a less than perfect settlement should be balanced against the stress, the time, the business disruption, potential reputational damage or damage to other contracts that you've got with other parties, the uncertainty and the potentially high costs of litigation, especially for lengthy court proceedings. So when looking at what we would call a commercial settlement, it is an agreement that parties reach which puts an end to a commercial dispute or business-to-business dispute. It may involve one party paying the other an agreed sum of money or doing certain things to resolve the dispute or the breach of contract. You can reach a settlement after negotiations that may take place in person, over the phone, or through written correspondence. While it's always best, in our experience, to start settlement negotiations before court proceedings commence, they can take place at any time, including after filing court documents or any time before the start of a trial. So, looking at the settlement negotiations, some of the tips for reaching these settlements prior to matters escalating is to narrow the issues in dispute. Parties may often have a number of issues that arise during the course of a business contractual relationship, which sometimes can span years. However, by raising all of these issues at the time your dispute arises, instead of focusing on the issues relating to the breach or current dispute, can often just delay matters and prove uncommercial. So I know that it's tempting to raise all the problems that you've had through a contract, but should just try and narrow those issues to try and come to a resolution. You should be clear on exactly what the dispute is about. Again, focus on the facts and circumstances relevant to the dispute. Try to rectify any misunderstanding amicably. Be prepared to make genuine attempts to resolve the dispute and compromise. And consider creative solutions to preserve the relationship or the overall purpose of the contract. So in terms of this, you probably want to revisit the contract. So whilst I'm sure everyone's aware you can't unilaterally change the terms of contract once entered into, they're binding, or force the other party to accept any changes, it's always open to the parties to mutually agree to amend, change, or vary contract terms to suit both parties and allow the performance of the contract, or to agree to mutually terminate the contract and terminate any obligations of the parties on termination. This form of mutual agreement is often considered when events which may not have been contemplated at the time the original contract was entered into have occurred, such as a sudden fall in prices, the development of a new technology, or unexpected delays in performance, which mean that parties would benefit from coming back to the negotiation table in order that the contract can be performed. This option is clearly more readily available in circumstances where the commercial relationship has been preserved, that is, parties have approached any dispute or breach in a non-adversarial manner. So, if you've successfully agreed the basis of any settlement, you should then consider the specific terms of that settlement. So, similar to the terms of a contract, any terms of settlement should be recorded in writing, whether it's to record the agreed terms of termination, for example, or a financial settlement arising out of any breach. A deed of settlement should include the following essential terms. So it should have details of the dispute, so the background. This will be long or short depending on the nature of the dispute. The date for when it's signed. The parties should be given their correct legal entities and clearly identified. So whether it's an individual, a company, or other association. You might also want to add extra parties if appropriate, such as individual guarantors. The deed should specify whether the contract is terminated or varied. There should be details of any settlement sum or method of payment in there. Key obligations should be included, so clearly spell out what each party has to do to comply with the deed. So it might include actions upon termination, which would be the return of equipment or products or IP, and any continuing obligations. So any restraints, sort of post-termination, confidentiality, non-disparagement, that sort of thing. So it should also include some default terms in there, so which will set out what happens if one party defaults on their obligations under the deed, and typically should include mutual releases. So here, both parties typically release each other from any legal claims relating to the dispute. Okay, well, that actually brings us to the end of our webinar. We hope you found the webinar informative. You might also find our free publication Guide to Resolving New Zealand Business Disputes helpful. You can download it from the resources panel. We also have an upcoming event that may be of interest to you. It's on business structuring for startups, founder equity negotiations and structuring considerations. And this will be held on Tuesday, the 25th of June at 12 p.m. So you can register for that using the link in the slide. The next thing, we will move on to talk about some of your questions shortly. While you submit them, I'll take a minute to tell you about LegalVision's membership. So LegalVision is a cost-effective alternative to have all of your business as usual legal needs covered. For a fixed monthly fee, you not only receive cost certainty, but all-inclusive benefits, such as unlimited document review, which would include reviewing your commercial contracts, unlimited consultations, which means you can book in as many meetings with us as you need to discuss your commercial contracts or any of your business as usual legal needs. You can talk to any of our lawyers, which specialise in varying different areas, including franchising, corporate, employment, etc., depending on your business's needs. A membership also offers unlimited trademark registration, all for one very reasonable monthly fee, with options to purchase extra credit towards complex matters and ongoing disputes, which are usually charged on an hourly rate basis. Okay, so now we're going to move on and just tackle a few of your questions that have come through. I think, Jess, do you want to take the first one?
Yeah, so this was a two-part question. The first part being, can my supplier use information provided by us to them from shipping information or open communication who we work with to directly approach our customers in the intention to sell directly to them? And can they cancel the contract of supplying the goods without notifying us or giving a notice period? So regarding the first question, whether your supplier can use information provided to them to directly approach your customers would depend on the specific terms of the contract or the agreement between the parties. If there are no restrictions outlined in the contract, for example, it might be verbal, or there is no non-solicitation clause, the supplier may be able to approach your customers directly, unfortunately. If there is an agreement that prohibits them, such as a non-solicitation for customer lists or an exclusivity clause, then obviously that could be a breach of the contract. So as for the second part, cancelling the supply contract, again, this would depend on the terms of the agreement. If there are notice periods in there or requirements to provide advance notice, then the supplier would need to follow these. If there are no such clauses, they may be able to terminate without notice, unless there are implied reasonable notice requirements. And this could be based on well-established, business relationships or trade practices. Ultimately, the specific terms of your contract with the supplier would be governed by the contract. And if it's unclear, then it's probably best that we review it. That's probably how I can answer that question for you. But obviously, if there's anything more specific, you can book in.
Thanks, Jess. Okay, I've seen another question here. So should I withhold payment under a contract if a dispute arises? So once you've gone through all the helpful steps in our webinar about how to approach your dispute and knowing your legal position, you should really only consider doing this if the payment of, say, an invoice, for example, directly relates to the issues in dispute. So, for example, if services haven't been provided, but really you need to be aware of what your contract says in relation to the dispute and the facts and circumstances, etc. So generally, if you don't dispute, for example, that 3 invoices are due, but you only dispute the last one, you should pay those ones that you don't dispute, because the risk is that you're generally just making the problem bigger than it is and potentially wasting time and resources arguing about something that's actually not in dispute. So that's, again, sort of pulling it back to narrowing the issues in dispute. And also, you know, sort of generally the higher the sort of amount in dispute, the more tempted parties are, I think, to litigate and to sort of make it a lot more adversarial earlier on. So this is all about, you know, considering preserving your commercial relationships again. There may also be a risk of you actually being in breach of your contract as well for withholding payment. So that's something that you always need to consider as well. And I think if in doubt, it's always good to seek advice before taking that sort of action under a contract. Okay, Jess, is there any other ones there?
Yeah, I can see another one. Which country or law will apply to my business contract? So the answer to that is basically, I mean, if it's written down, there should be, or most business contracts would have the governing law, and it would set out which state or territory, or it may be, or country, has the jurisdiction. If there is no choice of law clause, it is typically determined by the locations of the contracting parties, or where it was formed, and whether, you know, for certain type of contracts, the jurisdiction, for example, for buying and selling land, might be determined by the location of the subject matter. So the best approach is probably to review the contract and see if there is any governing law provisions. And if there's not, it might be best to consult a lawyer to analyse which jurisdiction's laws probably might apply.
Thanks, Jess. Okay, we've got another question here. From the point of view of a small business, what is the best way to document resolution to a dispute to avoid further disputes on the same issue? Okay, so this links back to our discussion about deeds of settlement. So the list of essential terms that we've set out in the slides apply to both small businesses and larger corporations alike. So they're kind of the foundations for a deed of settlement. For larger, more complex or higher value disputes, I mean, deeds can obviously get a lot longer and more complex, but the usual terms usually stay in there. So the deed for any dispute would usually provide a release for all claims arising out of or related to the issues in dispute. So you can typically stop or use it as a bar to further disputes about the same issue between the parties. So it's essentially meant to just put the issues relating to that dispute to bed. If there's generally conduct that has arisen as a result of that dispute that you want to try and prevent in the future, or are you worried about that it might happen with other parties that you're contracting with, for example, this might be a time when you want to consider if there's something that you want to put into your contracts or even your terms and conditions on your website, for example, to be accepted by parties that you typically contract with to try and avoid these sorts of issues in the future, or at least sort of reduce the risk of the same issues arising. So, I mean, it really will just depend on the facts and circumstances relating to that particular dispute as to what action that you can take. We'll have a look and see if we've got some more questions. Jess, did you have another question that you wanted to answer here?
There was a question in here, I think, about restraints of trades. Hi, how relevant and enforceable are restraints of trade, especially when one person's main source of income relates to business covered under the restraint of trade? I mean, some of these questions are quite specific, so I'm not sure if that's in relation to an employment type situation or an independent contractor. Assuming it's business related, then obviously, I mean, it depends on what the terms are with regards to the restraint of trade, and if this is written or implied. So yeah, I think there's a few in here about lease agreements as well that might be a bit more case specific. So if there are some more specific questions, probably would get you to submit them, and maybe we can set up a call to answer them later.
Yeah, okay. All right, thanks, Jess. I think there was a question in here too that asked about debt recovery options in relation to businesses and contracts. So, I mean, again, that's outside of the scope really of our webinar today, but there are obviously a number of options that businesses can take in relation to debt recovery. And I know that's a big thing, especially for small businesses, can cause quite a lot of problems, you know, chasing sort of debt recovery. So, In terms of first steps, would always be to issue a letter of demand. So businesses can send those out to debtors. We find sometimes that as a point of escalation, a letter from us, letter of demand can sometimes help move things along, but we provide full service in relation to debt recovery issues. And again, if you want to use your consult to find out more about how LegalVision can help you with your debt recovery needs, certainly give us a call. Okay, all right. Well, I think that's all we've got time for today. We just want to come back and say that we'd really appreciate it if you could complete the 30-second survey. So please include your contact details to receive a complimentary legal consultation to discuss how we can help you with navigating your business disputes. And yep, so just thank you so much for joining us today. We hope you enjoyed our webinar.